Good afternoon. Good afternoon. This is my pleasure to welcome you to this event. My name is Tamara Lawson. I'm the Dean of the School of Law. I'm the endowed Tony Remby Dean, and I'm here with the faculty of the School of Law. I'd first like to thank the Provost Serio, for initiating and funding this important conversation in lead up to the election. And I'm happy to welcome you and to this conversation, rich conversation with our faculty around presidential authority. In the words of Supreme Court Justice Ruth Bader Ginsburg, quote, "The Constitution, as important as it is, will mean nothing unless the people are yearning for liberty and freedom," end quote. And I'm excited that we have a full crowd of students engaged around the Constitution and its meaning. We have our legal experts in election law and constitutional law here today to break it down for you. Professor Liz Porter, Professor Lisa Manheim, Professor Jeremiah Chin, and Professor Danieli Evans. I'm going to leave it to the panel to go over and introduce themselves further. Their extensive bios are on the website, but trust me, you have the cutting national experts in this area, and this will be a robust and detailed discussion. Thank you.
Hi, for those of you who I don't already know, my name is Liz Porter, and I've just agreed to be the kind of MC moderator for today's session. Before we start, I just wanted to note that we're using this new app called Slido. Constitution is fine, pronunciation of verbs, I struggle. And you can get Slido by taking, capturing that QR code with your phone, and what it enables you to do is either to submit questions to be asked at the Q&A, or even if you do not wish to submit a question yourself, you can vote on other questions that people have posted so that we have a sense of which questions might be most interesting to the audience, and we can take those up during the Q&A session. Even though I'm introducing us, I will not be the first speaker, so I thought I'd just give you a quick preview of what's to come. First, Professor Jeremiah Chin will be speaking. Jeremiah's research lies at the intersection of constitutional law, race in the law, and federal Indian law. His recent research spans many topics, from children's rights to Confederate monuments. Today he's going to take on the big question. What are the stakes in a presidential election? And what are the stakes in this election in particular? Next, Professor Lisa Manheim will talk specifically about the landscape of American election law. Professor Manheim's specialty is constitutional law and election law in particular. Today, she's going to discuss how we deal with contested elections in this country and the threat of election subversion in the upcoming 2024 election. I'm going to talk next. My areas of research focus include civil procedure, constitutional law, and torts. And I'm going to take on the question of presidential power in a literal sense by addressing last term's decision by the Supreme Court dealing with the immunity of the president for attempting to subvert the 2020 election. Finally, Professor Danieli Evans, whose expertise is also intersectional, involving criminal law, criminal procedure, and social science and the law. She's going to discuss mistrust of governmental institutions, social science evidence on that mistrust, and what that means overall for voting, for election integrity, and for our functioning of our democracy. First, I'm going to give the podium to Jeremiah.
Thank you so much, Professor Porter, and thank you all for being here, and thank you for having me. I'm thrilled to be here to talk to you about the presidential election and the Constitution, and especially think about the idea of the stakes of a presidential election, especially because so much focus and social attention is dedicated to these presidential elections. We see higher voter turnout in years where a president is being elected than in our local and regional state elections, even though those local, regional, and state elections play an outsized role in the policies and laws that impact us most directly, the presidential election gains a lot of the national attention. Why is that? Well, from a legal perspective, from a constitutional perspective, the president doesn't have a ridiculous amount of power. The president doesn't have the power to make laws. The president cannot unilaterally implement policy. And that's, of course, because we're trying to create a system that isn't just some divine right of kings created by, women in lakes throwing swords at people, right? We're looking to create authority derived from the masses, people-based power that leads to democratic governance in theory. So what the Constitution does to fix that is it puts all of the legislative or lawmaking power in the hands of the Congress, right? Article 1 of the Constitution vests Congress with the legislative powers herein granted, whereas Article 2 creates the executive branch and instead vests the executive power. What exactly does the Constitution mean by the executive power? The Article 2 provides some hints and clues and some key defining terms. One, it makes the president the commander-in-chief of the armed forces. So while Article 1 explicitly says that Congress is the one who has the sole power to declare war, any troop movements, any use of military force is authorized and at the discretion of the president. So one of the foremost areas that the president has been authorized to operate and act and have as much discretion as anybody else is in this area of international affairs. Part of that comes from the commander-in-chief powers, but then the Supreme Court has read other sections of the Constitution in Article 2 to understand that there's also the president's role to receive ambassadors. So the president's job in hosting parties for foreign ambassadors and officials and other public ministers suddenly grants the president with some kind of inherent authority to set the face of the nation. So part of the reason why the president plays such an outsized role in our electoral process, I think, is because the role of the president sets out and defines the role of the nation. It sets the tone. It says what the country, or at least some majority of the country, or at least in some elections, the majority of the electors of parts of the country think of our nation or the status of our polity and what we want the face of our country to be in international affairs. In the 1930s, the United States Supreme Court kind of defined this power and defined the role of the president as the, quote, sole organ of the United States in international affairs. And that means that the president is kind of the face of the nation and the one who defines and sets the policy, who sets the tone for how the United States acts, interacts, where and when it sends weapons, where and when troops move. The president has this kind of concerted discretion that no other branch of the government really has, because the president sets the terms of engagement. In the Curtis-Wright case, Congress had authorized the president, if the president so deemed necessary, to punish anyone selling arms to two other countries, Bolivia and Paraguay, that were at war at the time over the Chaco Canyon border dispute. So in this border dispute, Congress declared that if the United States wants to maintain neutrality and the president decides it's important, the president can punish anybody selling any weapons to any side. And so the private corporation, the Curtis-Wright Export Company, thought it'd be a really good idea to sell weapons to Bolivia, and FDR immediately punished them, and through the Department of Justice enacted proceedings. They, of course, like a lot of folks that we see in constitutional law, rather than saying that their actions were justified or legitimate, they instead challenged the authority of the president to do anything whatsoever and said that the president had acted outside the scope of their constitutional authority. The Supreme Court decided that, especially in the realm of foreign affairs, the president's power is very broad, implied, and expansive. So when we're dealing with international relations, the president, as the face of the nation, has this outsized role in setting the tone of what the United States does, how it acts and interacts, in setting up different aspects of foreign policy, which the Supreme Court has decided over the past few years is fairly broad and expansive, even especially with regards to the recognition of other countries or how the United States interacts in the world sphere, is largely at discretion of the president and the executive branch in and of itself, right? So when we're electing a president, we're not just electing this one person, but we're enacting and electing one person to enact some of the other powers of the president. Some of the other stuff that Article 2 gives to the sole authority of the president is the power to appoint inferior officers at their sole discretion or appoint primary officers and receive their advice and consideration on different issues of state or international affairs. The big exception for the appointment of primary officers is that that requires the advice and consent of the Senate, kind of like the treaty-making powers of the president, also in Article 2, which is a part of their big, broad, discretionary foreign affairs power. But if the president wants to set up a Secretary of Labor, Secretary of Agriculture, Secretary of the Department of whatever internal agency you want to think of, the primary officer has to be appointed with advice and consent of the Senate, but the president is the one who puts that person before the Senate. So the president not only becomes a figurehead for the nation in external affairs, but kind of becomes the head of the snake when it comes to our big, beautiful bureaucracy we call the federal government these days, right? The way the president and who the president selects is as much of an impact on our domestic policy as anything else, even if their powers under the Constitution per se are a little more limited. Now, Congress has to authorize and approve all the different advisors and officers that get appointed, but the president, especially from the Supreme Court in the past few years, has the sole discretion to start firing people. So the president not only has the power of appointment, but the power of removal. In recent cases like Celia Law or Celia Law in particular, dealing with the heads of federal agencies and newly created federal agencies, these protections like an officer can only be removed for cause, the Supreme Court has looked very disfavorably upon because the Supreme Court has said that these officers lack any kind of democratic check. They're not elected, they're merely appointed with the advice and consent of the Senate. They hold terms for an undefined manner sometimes by the congressional branch, which is also a very weird decision from a group of 9 unelected appointed officials. But the Supreme Court decided that this lack of democratic oversight meant the president had to have the ability to remove those primary officers at their own discretion. So the firing power is just as powerful as the appointments power, but weirdly enough, thanks to presidents like Taft, who was weirdly both a president and a Chief Justice of the Supreme Court, now we have cases like Humphrey's executor that the president's power is to remove is incident to the power to appoint, not the advice and consent of the Senate. So while the president requires congressional approval to set up heads of agencies and construct the administrative state at their discretion with each new administration, the president has to get consent of Congress to set it up, but has the sole discretionary power to start firing and removing people at will, particularly under recent Supreme Court jurisprudence. So the stakes of the current and coming election, I think, are a lot higher than just creating a face of the country or just kind of these figurehead slogans. We hear a lot of stuff about the scope of executive power in terms of what presidents promise to give to people or what presidents promise to do, or even what presidents are blamed for, right? When we look at the Constitution, however, the president's authority is relatively limited, but the court's interpretations have given it kind of a broad grant of power, particularly in international relations, even when the president says, I don't know, terrible and racist things. In Trump versus Hawaii, early on in the Trump administration, the then President Trump created what he called in public statements and on social media as a Muslim ban, attempting to limit the immigration and visiting of people who believed or were of Muslim faith or origins, or generally originating in the Middle East. Fairly blatantly racist anti-Arab law. But in the final decision by the court took into consideration all the public statements of the president, but then said because the president is acting within the scope of their powers as the sole organ of international relations, as the face of the nation in setting the tone and policy for foreign affairs for the United States, their power would only be subject to what the court calls rational basis review. Meaning that if the court could find some constitutional ground or some constitutional basis for the president to authorize this level of policy, then the court would be able to say that it is constitutional rather than finding it unconstitutional on grounds like equal protection or strict scrutiny. which is a very interesting position to me for a court that as recently as last year in the Students for Fair Admissions versus Harvard and UNC cases found that any use of race or any acknowledgement of race in higher education was suddenly anathema to the Equal Protection Clause or any notions of equality that our society holds dear. But rather the president is given a full and broad discretion to say racist things in public, but not have any constitutional consequences from the Supreme Court. One of the biggest trends we've seen out of the Supreme Court, particularly from the last term, is the amount of discretion that the president is granted and who has the discretion to determine when the president is in or out of line. And that's the Supreme Court. So the Supreme Court in Trump versus Anderson and Trump versus United States, there's a weird common thread between a lot of these cases I mentioned. In these last two cases that were before the Supreme Court in our most recent term, the Supreme Court is the one who determines whether or not something is within or without the official scope of the powers and duties of the president. They are the ones who determine whether or not the president has acted outside of the scope of their authority or caused insurrection to the United States. So while the president plays such an outsized role, the president's appointment power also has a long-term consequence for us in the United States in determining who sits on the Supreme Court and who has the power to determine whether or not the president has acted within the scope of that authority. So this has been kind of a very, very bird's eye view of what the Constitution says about executive power, and I want to make sure that we have enough time to hear from the brilliant people on the panel. But there is so much at stake in the presidential election beyond the surface that I hope everyone takes time to give it the full consideration.
There we go. Hi, thank you everyone for coming. I'm Lisa Manheim, and what I'd like to do today is talk a bit about concerns that I know that a number of people have over the possibility that a candidate running for office can somehow subvert an election, including an election for the presidency. And I'd like to talk about this because it implicates questions of law. In a sense, the central issue here is whether the law of elections will hold. And that's an area of research for me, and it's very important. But I'd also like to talk about this issue because it may be the case, and it seems like it probably is the case, that heightened concerns over whether the process is, in a sense, rigged, tends to suppress voter turnout. So if people think that an election might be subverted, they are less likely to bother to cast a vote in the first place. So addressing these sorts of concerns over election subversion may actually, in and of itself, help to address some of these problems of voter engagement. Now, when I use the term election subversion, I'm referring to an attempt by some actor in the process to exploit a breakdown in the rule of law in order to essentially install a candidate into elected office. And the most common manifestation of this concern is that one person would, in a sense, win the election, get more votes than the other person, but that the law of elections won't hold, and as a result, some other candidate somehow is declared the winner of that election. Now, based on my understanding of the relevant legal frameworks, this danger of election subversion is real, but in my view, it tends to be wildly overstated. So why is this? Let's take a second and back things up. So this concern over election subversion, it exists in every election, regardless of who is running, regardless of what period of time we're talking about, and so on. And as a result, we have, over time, generated and developed and put into place a really robust set of legal mechanisms that work to counteract attempts at election subversion. And on that front, to remind you, we've been running elections in this country for literally centuries. And what's more, after the threats to the rule of law that we saw after the 2020 elections, many people have been working very hard to implement additional reforms, including legal reforms, to further reduce that risk of election subversion. And you might think of these different reforms as sort of falling into three broad buckets. So some of these reforms are preventative. And by that, I mean the reforms, these legal reforms, attempt to get rid of opportunities to commit election subversion. These sorts of reforms might be, for example, statutes that legislatures pass to make it clearer ahead of time which sort of absentee ballots should be counted and which sort of absentee ballots shouldn't be counted. And by making the law clearer in that way, it actually takes away discretion from various election officials around the country with respect to that same sort of set of questions. Now I'm going to interrupt myself really quickly here to say one thing. So the way that we run elections in the United States, they're run by states, not by the federal government. And what that means is that we have all these different sort of election systems across the country. It's decentralized. That has a bunch of problems, but one of the huge advantages is that it's actually really hard to subvert elections across the entire country because you have to subvert it over and over and over again. And partially because we have this decentralized system, we employ thousands and thousands of people every election to help run our elections. They're complicated. Think about it, right? It's like millions of people coming together to do the same really important thing more or less in the same way. I mean, that's really, really hard to coordinate and run. So we have thousands of people working to help us with that. And the vast, vast majority of them historically have been operating in good faith, trying to do their best to implement the law. But of course, is there the threat of some election officials somewhere attempting to engage in subversion? Of course. So again, these sorts of reforms that limit the discretion people have help to prevent election subversion to begin with. The second kind of broad bucket of reforms you might think of as being incentive-based. So what these reforms do is they make it, in a sense, less attractive to try to subvert an election and more attractive to try to uphold the rule of law. An example of this, how about we prosecute people who commit crimes in the course of trying to subvert an election? And we've seen that over the last number of years, right? The last few years. We've seen prosecutions of people who attempt to interfere with the election process. The flip side, try to support people who are working to uphold the process. Give resources to these election officials that I'm talking about. Finally, the third sort of broad bucket for these reforms you might think of as corrective. And these corrective reforms, they anticipate that some of these attempts at subversion are going to happen. Even if we try to prevent them, even if we try to change the cost-benefit analysis, some people are going to try to do it anyway. And so these corrective reforms try to respond to attempts to subvert an election after the fact and make sure that that attempt doesn't actually translate into an election result being changed. An example of that is we have legal mechanisms in place, ready, that will effectively remove election officials who refuse to certify election results and replace them with election officials who will, right? So if the law requires an election official to certify election results, that person has to do it, or there's a legal mechanism to remove that person and put someone else in. Okay, so on this front, one of the most important reforms that we've had over the last few years is called the Electoral Count Reform Act. I'm just curious, has anybody heard of the Electoral Count Reform Act? Nice. Okay, 3 people are like, yeah, I did. All right, so I'm going to call it, that's sort of a mouthful, so I'm going to call it the ECRA. And in 2022, Congress passed the ECRA, and if you can believe it, they passed it by a bipartisan vote. So you had Republicans and Democrats voting on the same statute. And this act, this set of reforms, it responds directly to what happened on January 6, 2021. And on that front, this ECRA accomplishes a great deal. It tries to prevent attempts by members of Congress, for example, who might want to subvert election results by requiring that 1/5 of each House of Congress, right? So at least 1/5 of the members of Congress in each House support any attempt at challenging an election, an electoral count. The vote coming out of the Electoral College, all right? And that is a far higher threshold than what we saw in 2021. It also limits the types of challenges you can bring. That's preventative, right? So it's trying to reduce the opportunities for subversion. The ECRA also tries to change that cost-benefit analysis. And on that front, what it does, among other things, is it imposes all these additional legal roadblocks if a state legislature tries to, after an election, just change the election result. So it imposes so many legal roadblocks that it makes it less enticing for a state legislature to go ahead and decide to do that. And then also, that's the sort of cost benefit, the incentive base. It also attempts to correct subversive attempts that happen after the fact by creating this expedited process for certain types of challenges that now need to go into the courts. And then the courts decide the relevant challenges, and then Congress is bound to follow the rulings that the court reaches there. Is the ECRA, so I've sort of talked about some of the reforms that it sets forth. Is the ECRA going to eliminate all danger of subversion in the election that's about to happen in just a couple weeks? No, of course not. That being said, through this really careful, kind of multifaceted approach, this statute really significantly reduces this risk. And this is just one statute. This is a statute that responds directly to the concerns that came out of January 6, 2021, and by extension to the concerns that we are now seeing again with respect to January 6, 2025. But this time, unlike last time, we have these legal guardrails in place. Okay, so that's one statute, one set of reforms. But like I said before, look, every election carries with it a vulnerability to election subversion. Have any of you seen the movie Election? It was made before a number of you were born. Okay, so we have, yes, all right, so right. Well, in this election, basically, in this movie, I won't bore you with it, but basically there's there's an attempt to subvert an election for student body president. And the reason I bring this up is just to remind you is that this sort of concern is not new, right? This is not the first time somebody's tried to subvert an election. It was not in 2020, and it's not gonna be this year. It happens throughout history. And so as a result, the legal system has been anticipating these sorts of attempts from the very beginning. And as a result, we have a robust set of precedents and laws and procedures that are all intended to minimize that risk. One quick example, for those of you who are interested in law school or otherwise are sort of like the weeds, we have this thing in law, deeply embedded in law, called the principle of laches. And what the principle of laches says, essentially, is, ready? If you could have brought your challenge before and you decided not to bring it, you can't bring it now. And so we say that with respect to people who try to challenge elections after the fact. We say, look, if you could have complained about that before the election, but you just waited to see whether or not you won, you can't bring your claim anymore. Okay, so that's just one illustration of how the law responds to this. Okay, so to return to what we started with, given my understanding of the legal system that governs our elections, can I tell you with certainty that the election will not be subverted? Do I know for sure, in other words, that it's going to proceed in a manner that's consistent with the rule of law? No, I can't tell you that. But here's the thing, I wouldn't have been able to tell you that 8 years ago, I wouldn't have been able to tell you that 20 years ago, and so on. There's always going to be a possibility of this. Instead, what I can tell you is this. Personally, with respect to the upcoming election, I'm a lot more concerned about politics rather than law. So I'm not as worried, in other words, about whether votes that are cast will be properly counted as I am about what votes are going to be cast. And by this, I mean first, I'm worried about people not voting. I know that Professor Evans will talk a bit more about this. There are many factors that go into the likelihood of someone voting, and these dynamics can produce any number of pathologies. And second, I'm worried that once people do vote, the result may be so close that the law, in a sense, will struggle to identify a winner. But here's the thing, what I just said, a really close election, that's actually a different problem than the problem of election subversion. And I think this distinction is really important to make, because as I suggested before, when people think the system is rigged, they don't vote. But that's exactly what we need them to do. Okay, so those are my thoughts on that.
So Professor Manheim was talking about a really complex system that to some extent is insulating us from the harms that can come when people try to subvert democracy. I'm going to just move to a slightly more cynical tone and talk about a really simple Supreme Court case that concentrates power in the hands of a president and limits our ability to hold that person responsible if they break generally applicable criminal laws. The court's decision, which came out last July in Trump versus the United States, embodies a view of the president, and these are the words that the court uses, that it's vigorous, bold, unhesitating. Is anyone hearing something gendered here? Anyone hearing some gendered words? And it's concerned about doing things that would, quote, enfeeble the office of the presidency. So in this case, which results from an appeal of Jack Smith's attempted prosecution of Donald Trump for violating multiple laws in an attempt to alter the outcome of the 2020 election, has resulted in a decision. First of all, this is the first criminal prosecution of a president, sitting or former, in our nation's history. And it's resulted in a ruling that I think at its worst can be kind of almost like a blueprint for laws you can violate while you're president. What the court does is it holds that the president is immune under certain circumstances. And for those of you who are not lawyers or following this very closely, I want to just briefly explain what immunity is, right? Because you may think of it more as a COVID thing. So immunity is a status that comes from either a legislature or a court that basically says, if you have this status, then you cannot be held responsible in a court of law, either criminally or civilly sometimes, even assuming you broke the law. That's the key thing. And immunity actually protects people not merely from being punished, so not merely from going to jail or having to pay money, but also from even being brought into court and tried. So when it happens, when it's in effect, it's actually a quite serious protection. Who tends to get immunity? People with power, people or organizations with power. Sometimes immunity can come from legislatures. For example, this term, the Supreme Court will hear a case brought by the country of Mexico suing United States firearms manufacturers for essentially what they're arguing is selling enough weapons that they know are being shipped to Mexico and causing thousands of people to die, that these firearms manufacturers should be responsible, they should be held liable. But Congress passed the Lawful Protection of Firearms Act. Let me just see if I can find it. The Protection of Lawful Commerce in Arms Act, which bars liability for torts committed or crimes committed downstream by firearms purchasers. It's unclear exactly the details of how that case will be decided, but for Mexico, for multiple reasons, that is an uphill battle. You also may have heard vaguely of Section 230 immunity, which provides protection for social media platforms for being sued for torts that arise, for example, from people who are radicalized by watching YouTube videos. Our colleague Eric Schnapper represented plaintiffs in the United States Supreme Court trying to pierce that immunity in a case against Google, which was unsuccessful. These are immunity doctrines, these are immunities that are granted by Congress. I'm just guessing that no one here has that kind of power. You're probably not immune for anything. Some immunities come from the Supreme Court as a matter of the Constitution. So, for example, states and the federal government have sovereign immunity. They cannot be sued without their consent. And this immunity that applies to the president of the same type. And the court grounds these immunities in different things. This immunity, presidential immunity, it grounds in a sort of mealy-mouthed way in what it calls separation of powers. Sovereign immunity, it didn't even do that. It just said, of course, the sovereign is immune. It kind of like said almost as a matter of natural law. But these immunities granted as a matter of the Constitution cannot be overturned by a legislature. So we need to take them as a given unless the Supreme Court changes its mind, because the Supreme Court has the final say in the interpretation of the Constitution under our system of laws. So before this, we had not had a criminal prosecution of a sitting president, but we did have a little bit of action here in the civil context. So this is not about Watergate, but it involves Richard Nixon. There was a guy Fitzgerald, he was an Air Force analyst, and he testified in front of Congress that some airplane was the airplane development, the budget was overrun, he kind of whistle blew on the Air Force about the development of an airplane, and he was fired, and Richard Nixon took responsibility for his firing. Whistleblower, retaliation, done. Court finds that sitting and former presidents can't be sued civilly. Civilly means for money damages. So you can't be sued for your official acts, anything within what they called the outer perimeter of your official acts, which is kind of a weird term, but it becomes very important now. So no civil suits, but we didn't have anything on the books with regard to criminal liability. And many people, including Richard Nixon, assumed that they could, in fact, presidents could be held liable for violating generally applicable criminal laws. It makes some sense. As Jeremiah explained, our president is not a king. It makes some sense. But in Trump versus United States, the court largely applied the Nixon versus Fitzgerald framework in the context of criminal suits. And it did this by creating 3 basic buckets. The court does not use the word bucket, but it's a very helpful way of thinking about it. So the first bucket is the bucket of things that the Constitution assigns solely to the president. So for example, the pardon powder, that's solely the president's, or the power to remove officers, as Professor Chin described, that belongs solely to the president. In that bucket, the president is totally immune from liability for prosecution. So there was kind of this sort of hypothetical that was floating around. Could the president auction off pardons on Twitter? It's called X now, whichever. And you kind of think, no. The answer is now maybe yes. Maybe yes, because the pardon power is protected by this absolute immunity. And in the case actually before it, which did not involve the pardon powder, but the removal power, Trump had threatened to fire his acting attorney general multiple times when the acting attorney general would not go along with his attempts to thwart the election. And the court basically said, sorry, that cannot be, no liability for that, because that is solely within the president's discretion. Impeachment is your only option. So that's absolute power. On the other hand, if the president just knocks someone flat in a barroom brawl, that's not an official act. They can be held responsible for that. So we have the core constitutional powers of the presidency, absolute immunity, bucket 1. Bucket 3 is unofficial acts, domestic violence, your regular old DUI. Presidents can be held responsible for their unofficial acts. They're still like other citizens responsible for following the laws outside of anything that's related to their presidency. This leaves a really big twilight zone middle bucket. And the court spoke about that middle bucket, so bucket 2, in a really unsatisfying way, because it didn't fully say that they could be responsible. It said, we're not deciding. It's possible that there's total immunity here too. It's possible, they left that open. But even assuming there's not total immunity, there's presumptive immunity. And the government there's a heavy burden to overcome that presumption. So what does this mean? What does this mean for this actual case? Well, this case in some senses was about timing as much as substance, and this is not going to be resolved before this election. So if there's an election, I think Trump, there used to be a question, can the president pardon himself? And the answer, if Trump is president, is going to be like, sure, unless he's impeached, there's no liability for that. So I think one way or other, if Donald Trump is reelected as president, this case will go away. If that does not happen, actually, Donald Trump himself remains in political jeopardy because there are acts that he committed that were that his counsel sort of stated oral argument is probably not an official act. There were some of the things he did that were so far out of the bounds of what the president does, no responsibility. But many of the remaining claims are in this twilight zone where we just don't know. So that's what's happening for this ongoing case, United States versus Trump. 3 things, and then I'll let you go. Just some overall commentary. This current Supreme Court purports to be originalist in its methodology. Originalism means that they are faithful to the way the founders interpreted the Constitution. This is sort of like if you decide to adopt the paleo diet. It's a way of putting guardrails around what you eat. Originalism is a way of putting guardrails around the way we interpret the Constitution. But you probably know people who were on the paleo diet until they saw the pizza. It turns out people are not consistent in how they eat. And they are also, even if they're Supreme Court justices, not consistent in how they interpret the Constitution. And that is true here. This is not an originalist decision. This is a decision of pure power. In fact, the Constitution's text indicates that presidents' impeachment only disqualifies them, but presidents are nevertheless still subject to conviction. So the textual argument for the Constitution goes the other way here, just to show that I think the interpretive methodology is a little bit complicated. Second, the court raises the image of the slippery slope, like, oh my goodness, if Trump gets prosecuted for these things here, Biden will be prosecuted for what happens at the border next, everyone will be prosecuted all the time. And okay, this is the first time that this has happened since the founding of the nation, so I feel like that's not we don't have a lot of evidence of this slippery slope on the one hand, but we actually do have a lot of evidence of the slippery slope of undermining elections on the other. So the third thing I want to say is what's most important to this case from my perspective isn't necessarily what it held, it's what it didn't hold. What did this case not do? It did not say that what happened on January 6th and the lead up to January 6th was a grave threat to our democratic system. It did not say that we all need to have respect for the rule of law, including the president, in a way that can help promote and support our democracy. And to me, its silence, its omission of these words is almost as important as the words that the court did say. And I think for all of us in this room, that, as much as anything else, should be a serious concern. Thank you.
Okay, well, thank you all. I prefer to use slides. I'm going to be talking a little bit more about some social science data today that is easier to present with the slides. So everyone on the panel did such a great job speaking about presidential power that I decided that I'm going to abstract out a little bit, and my presentation today is going to be the most broad of all the ones you've heard so far. I'm going to talk a little bit about voter behavior and how the government's conduct shapes voter behavior. And this is important and relevant in a conversation about constitutional law because the government's conduct is regulated by and moderated by constitutional law. And the ways in which the government's conduct shapes voter behavior, I will argue, has implications for the Constitution, for the values protected by the Constitution, like full and equal citizenship and representative democracy. So I'm going to start by talking a little bit about political participation among economically marginalized voters, and then I'll talk about political socialization and policy feedback. And then I'll give you some examples of what I mean by policy feedback or anti-democratic socialization in the context of policing and welfare agencies and how that shapes people's likelihood of voting. And then I'm going to connect it all back to the Constitution and presidential power. So where I want to start with here, and Professor Manheim alluded to some of this a little bit, is that there are big disparities in who votes based on income and education. And people that we might describe as economically marginalized, by which I mean having less income and less education, are significantly less likely to vote than people who have more income and more education, i.e. who have economic and political power. You can see, I'm not going to read all these numbers to you. There's the differences here are statistically significant, very significant, but among lower income voters, all the way up to $30,000 to $39,000 a year, around 63% vote. If you look at people making over $100,000 or $150,000 a year, it's 80 and 84%, and similar patterns with education. Now, there are lots of reasons for this, right? And I'm not purporting to talk about even the most important reason. Some reasons might be time constraints. You know, people who have lower income tend to have less flexible jobs. It's harder to get to polling places. It's more difficult to get registration. Transportation, knowledge about the candidates. Perceptions of fraud in the election maybe dissuade people from voting. But what I'm talking about today is what I'm calling political socialization, or the ways in which interactions with government shape people's sense of citizenship and how people's ideas about their citizenship and belonging shape their political behavior. And this is, while not perhaps the most significant predictor of voting behavior, it's an important one. Why? Because it's one that the government can control, and it's one that constitutional law can say something about. And so what do I mean by political socialization? So I'm drawing here not from my own work, but from a large body of sociology work. A lot of it's been done by someone named Joe Sauce, who's a sociologist, on what's called policy feedback. And the basic idea here is that interactions with government institutions teach people lessons about their standing as citizens and about the trustworthiness of government and the efficacy and wisdom of exercising their voice as citizens. This, to some extent, complicates the standard picture of democracy, right? The standard picture of democracy is kind of what I have illustrated here, where political participation, voters have ideas, they have preferences, they have interests, they participate in politics, and policy outcomes reflect their political participation. If people are particularly motivated to change a policy, they should go vote, and the policy outcomes will reflect that. The Supreme Court oftentimes in its reasoning, in various contexts, relies on that sort of assumption. The court will say things like, oh, if voters don't like the fact that the state legislature is criminalizing abortion, they should go to the polling place and vote for representatives who are going to change the criminal law. If voters don't like the way that police are policing this community, they should go to polling places and vote for representatives who are going to change policies governing policing. But the policy feedback literature counteracts this or complicates this picture because it shows that policies themselves change political behavior. So policing that is stigmatizing, subordinating, itself can cause demobilization. It can cause people to withdraw from politics and change their behavior in such a way that actually winds up reinforcing political inequality. And I'll elaborate on this with two examples in some of the data. So one example that's been studied a lot is experiences with the criminal system. And again here, I'm a legal scholar who thinks about the implications of this social science research for law. I'm not doing this research in the first instance, and I want to make sure to give credit to the authors who are. A number of different scholars now in political science and sociology have studied the ways in which interacting with the criminal legal system influences political participation. And there are many, many, many studies now showing that any encounter with a police officer, and we're talking now about people who are not convicted of felonies that lead to legal disenfranchisement. So these are people who are legally eligible to vote. Any interaction with a police officer, just a stop, not even an arrest, but then an arrest, conviction, incarceration, decreases the likelihood of voting by the numbers that you're seeing here. This is controlling for other factors that influence voting behavior, like education, income, all the other factors that I was showing on the last slide. It also even controls for voting in a previous election before the stop or arrest occurred. And the reason for this is because interactions with police are sites of socialization. Arrests are exceedingly common. It's estimated that about 1/3 of Americans have been arrested. For people living in certain heavily policed communities, your interactions with the police are your primary source of information about government. You learn about the nature of government from interacting with police. And if those interactions are inherently stigmatizing, subordinating, demeaning, if you're subject to a lot of authoritarian control, they teach you lessons that are fundamentally incompatible with the experience and reality of being a democratic citizen. Because democratic citizenship is fundamentally about being in a relation of equality with other people. And if you experience subordination at the hands of government, you experience something that is antithetical to being a democratic citizen. Another example of this comes from studies involving people who participate in welfare programs. There are similar findings in these studies. And so what you're seeing on this chart is a comparison between people who receive TAMF, which is a program called Temporary Assistance for Needy Families. It's a need-based welfare program that is largely administered by states. States have a lot of discretion in how they implement the program. And these programs are traditionally, in many states, very controlling and authoritarian. So people who are getting TAMF are oftentimes required to submit to random searches of their home, very intrusive interviews, sometimes about their personal relationships, a lot of questions about their child rearing, how they're raising children. There's some questions about whether drug tests can be required, whether that's constitutional. But the courts have allowed a lot of searches, a lot of intrusive behavior when it comes to TAMF recipients. And what you see here is the effect on political participation for TAMF recipients compared to Head Start recipients. Head Start is a very different federal program. It provides aid to parents with preschool children. And it's assumed a model that goes back to the maximum feasible participation era of the 1970s from the War on Poverty, which really emphasized incorporating the recipients of welfare into the decision-making process. And under TAMF, Head Start continues to engage parents in these participatory site-based policy councils and really reinforces a lot of behaviors that are conducive to democratic citizenship: participation, voice, respect, being included. Whereas TAMF is the exact opposite. It's controlling, it's stigmatizing, it's subordinating. There's a lot of sanctioning if you're not doing enough to get a job, et cetera. And so what you see here in the stars indicates statistical significance is that people who receive TAMF are significantly less likely to vote, could participate in politics, otherwise do civic participation and measures of engagement. I won't get into detail what those are in the study here, compared to those who receive Head Start. Head Start, in the latter two at least, has a significant positive effect on people's political participation. Again, here the idea is that these are sites of socialization. These are sites where you learn something about your standing as a citizen. This is just some qualitative data to support what we just showed quantitatively. There have been hundreds of interviews done now, and you have the sources on my slides. But this is the kind of language that people use when asked to describe government or asked to describe why they don't vote or whether they vote. This is somebody who has been convicted of a felony. One thing that is very common is that there's a lot of misinformation about whether you're eligible to vote as someone who's convicted of a felony. This person is eligible, but it's very common that people who have been convicted of felonies believe they're not eligible. And furthermore, the existence of many barriers, so like restrictions on re-registering or needing to pay all of your criminal system fees before you can register. Many of the other barriers that don't apply specifically to people with felonies, like voter ID laws, et cetera, interact with this socialization effect where people say like, oh, the government doesn't respect me, government officials aren't likely to listen to me anyway, what's the point of voting? And they compound one another, right? So you have someone saying, I don't believe in our government, I believe no matter who or what we try to vote for, they're going to do whatever they can to try and keep poor people like me down. So there's no point in wasting my time and gas money to vote when my vote don't matter anyways. And besides, I thought I wasn't allowed to vote because I'm a felon. And here's another one from another study. I feel like if I contact a senator or governor, they'll probably want to put me in jail and leave me there as a troublemaker. They have the money and power. Who the hell am I? I'm just a small peon at the bottom of a totem pole. These quotes are, I get said again, there's like hundreds of interviews in the books that I have up here, but they're capturing sentiments underlying this effect. There's a perception that my vote doesn't matter, I'm unimportant to government. There's a perception that government officials are not representative of me and my people. And there's a perception that it might even be risky or dangerous. If government is unrestrained arbitrary power, walking into a polling place could lead to any sort of consequence that I'm not willing to endure. Key point here is this is not race neutral, right? Neither of these systems are race neutral. So if you look, I have the rates of arrest, conviction, and incarceration among men by age and race. I'm not going to go into conviction and incarceration because just an arrest is enough to suppress participation. But you can see, first of all, the rates for everybody are staggeringly high. But a black man by the age of 36 has about a 46% chance of being arrested at some point in their life. Hispanic male, again using the categorization in the study, is around 35%, and a white male is just above 30%. And so we see racial disparities in these systems, and if you think about, we connect this to the disenfranchising or demobilizing effect that I'm just talking about. This isn't just a disparate impact, isn't only a disparate impact about the harms of criminal punishment, it's also about the secondary harms of political participation, right? This logic that if people don't like what the police are doing, or if they don't like the criminal law, they should go to polling places and change it. Well, if the experience of encountering the criminal system is itself demobilizing, then that's unlikely to happen. Similarly, what you have on the left side is the relationship between the racial composition of the TAMF caseload and the work-related sanction rate, which is a proxy for how punitive TAMF, temporary assistance for needy families, TAMF systems tend to be. And you can see that the more the caseload is non-white, the more punitive the TAMF system tends to be. And there's a lot of data to this effect showing that welfare programs are less generous and more punitive in states with higher populations of color. So what is the implication of all of this for constitutional law? So this sort of political socialization or anti-democratic socialization that I'm talking about is both caused and sustained by constitutional law, and it has consequences for constitutional law. What we have is a system, this has been called by sociologists to be a degenerative policy system, where we have two systems operating in the US in terms of public administration and what people experience when they interact with government. We have a system for economically powerful people, which typically receive fairly respectful treatment in the context of policing. Welfare, by welfare, I mean something like Social Security insurance. It's a universal program, which is oftentimes held up as an example of a program that's very respectful to deal with and very responsive. Schools, right, we all know, I assume you know about the income-based segregation in schools as well as race-based segregation, and that students who attend schools in higher income districts have very different experiences from those in lower income districts. And work, the way that the workplace is for higher income people and the extent to which they experience autonomy is very different from the workplace for economically marginalized people. And what this breeds is a sense of trust in government, a sense of entitlement to participate, which then leads to more participation, which then leads to being overrepresented in political institutions, which then leads to more respectful treatment and more favorable policies. Whereas at the same time, on the left, you've got a system operating for economically marginalized people that does the exact opposite, right? Subordinating treatment in policing, in welfare, in the ways I've just talked about, in schools in the way I just mentioned, and in the workplace, which is something I don't have space or time to get into here. And this leads to distrust in government, withdrawal from politics, and if not withdrawal from politics, perhaps willingness to vote for candidates that are disestablishment or that reject the establishment or reject conventional institutions, because if those institutions are not trustworthy and not looking out for your interests in the first place, why not vote for someone who wants to burn them all down? And then from that, especially with the political withdrawal, you get underrepresentation in political institutions. There's a lot of data showing that both in Congress and the presidency, of course, the preferences of lower income people are not considered nearly to the degree as the preferences or interests of higher income people. The consequences for constitutional law is that we have a system of ongoing political inequality where institutions are not representative of economically marginalized people. And this is a result of the court's very narrow and thin conception of citizenship. In thinking about democratic citizenship, the court has defined citizenship in very formalistic terms. It's adopted a thin conception of citizenship, meaning something like you have a formal right to vote and cast a ballot. But it's continually rejected any consideration of the ways in which interactions with government communicate messages about people standing in the community. The court has been very reluctant to hold certain policing or welfare or educational or work-related policies unconstitutional because they are subordinating or stigmatizing or demeaning, or because they have disparate effects on lower income people or people of color. It's resisted all of those ideas. And so while it articulates a formal right to vote and a conception of universal citizenship, it fails to ask how other interactions with the state undermine this message of full and equal citizenship, and therefore really strip a lot of our citizens of the experience of being full members of the polity, and then how that has downstream consequences for their voting behavior and our ongoing political system, the representativeness of our political system. Thank you.
Now I'll take some questions from the audience. This one is for any of the three of you. What do you think about term limits for Supreme Court justices, and what impact might that have?
Short answer, I think, it would have an outsized effect on the Supreme Court and how it works and operates currently. I think the biggest effect of imposing term limits on the Supreme Court would be that it would mean a constitutional convention, because the Article 3 says it's for good behavior, right? Good behavior is not a duration of time. So imposing term limits on the Supreme Court would mean we're revisiting the whole thing, which I think is pretty cool, but is opening Pandora's box a bit. If we put term limits on the Supreme Court, it would significantly, I think, affect the ways in which the court is able to operate and certainly have much more turnover in terms of justices, but would require serious reevaluation of like our whole constitutional structure, which I'm in favor of.
Yeah, does anybody else have a view of that? Oh, it's wired in. Okay, the batteries are just being changed. So I guess what I want to say is that recently President Biden commissioned a commission of a bunch of judges and scholars and experts on the Supreme Court to consider what reforms might be overall beneficial and viable at the court. And there's a lot of pages to it. You can find it online, and you can find the summary of it online. And term limits were one of the things that it considered. Also considered situations where the Supreme Court justices took turns serving as judges on the lower court, so there was kind of a rotating idea. It considered the popular but politically non-feasible concept of packing the court, so changing the number of people on the court. So they considered a bunch of these ideas, and my takeaway is at the end of it, they wrote a very long report that said that these would be nice, but not really recommending any of them. So the question is, how much political time and capital do you want to invest in this if you think it would require a constitutional amendment or some other major transformative thing? And if whatever change you anticipate making, if you're looking for the court to have a different political inflection, if that didn't happen, would these changes in fact benefit you, or would you be more in a hole? So, right, in the kind of behind the veil of justice, what would you like to happen? These are hard questions to answer. Okay, so next question. Do we now have to worry about president-ordered assassinations of political rivals as an official act because they'll be immune because of national security interests? I can hear the laughter, and I'm going to put up this to the panel, but I just want to note that this was actually a major hypothetical at the Court of Appeals. When this immunity case was argued at the Court of Appeals, one of the judges just kept saying to President Trump's lawyer, "Are you saying that the president could order SEAL Team 6 to assassinate a political rival and that president would be immune?" And President Trump's attorney, who definitely had like some sort of stiff drink before the argument, was like, yes, I do. Yes, the president would be immune unless the president could be impeached. Impeachment is the only recourse here. And I think that let's see what the panel said. I think that the answer isn't quite as cut and dry as that, but it's a little bit depressing.
This is can you hear me? Yeah, so I think this is a hard one if you read the opinion, right? I think it depends, Professor Porter was talking about that middle area, powers that are shared by Congress and the president, and what it really would come down to is whether the court characterizes this as something that is, in the core part of the president's power, like pardon power, or they say in the opinion that, threatening to fire the attorney general or a core advisor is within the core part of that power, because that's something the president gets to do. Maybe commander-in-chief of the military, it would fall in there, but it really depends on the circumstances of the assassination and whether it's, exercising that power. And I think there's some interesting, questions about, for example, like in Justice Barrett's concurrence in the case, she says you have to, not that this is the deciding opinion, but she says, we should really analyze the statutes carefully to see whether they even criminalize what the president's doing. And she gives an example of how the Office of Legal Counsel has long interpreted, like, homicide laws, for example, to exempt certain forms of targeted killings because in the course of military action that doesn't apply. So there might be a lot of nuance around what is the situation, what is the statute being applied, what power is the president exercising. But this all gives you a sense of this sort of analysis and how that analysis would work after the Trump v. US opinion.
Thank you. Thank you. Okay, how about this? What would have happened if Mike Pence, Vice President Pence, had done what Donald Trump had asked and certified an alternative slate of electors on January 6th?
So I'm not sure that this question's been satisfied, or this answer's going to be satisfying or not, but So there's something that's called a constitutional crisis, and the way that I think of a constitutional crisis is that it's a problem that the Constitution, in a sense, anticipates. There's something about the framework of the Constitution that allows a certain problem to occur, but then the Constitution doesn't resolve that question. And that is something that in law is sort of by definition, there is not a constitutional answer to it. There's not a legal answer to it. And that's one thing that I think is sort of thematic across what a lot of us are talking about in this, this talk, which is to say that the law is going to give us a lot of insight into how things are likely to be structured, what's likely to unfold. But at the end of the day, at some point, law runs out. Particularly when we have somebody or a number of people who are sort of willing to go beyond law to the extent that there's not something that's constraining it, right? So if somebody's willing to break the law or to bend the law, then it is difficult to respond with a purely legal answer. So that's kind of a sophisticated way of saying the not sophisticated answer, which is ready. I don't know, that would have been bad, right? So there's not, it's one of the reasons why it was so problematic, and one of the reasons why Congress on a bipartisan basis came together to enact the Electoral Count Reform Act. The Electoral Count Reform Act, for what it's worth, makes it clear, and by the way, I already thought this was the right answer, but now it makes it even more clear that the Vice President is not permitted under law to take that sort of step.
Just looking at these pictures. Okay, so I think, Professor Manheim, this might be to you again. Let's see. The Supreme Court gave Trump immunity for when he tried to get his Department of Justice to fabricate voter fraud claims by firing his acting attorney general, or threatening multiple times to fire the acting attorney general. If Trump is reelected, can he not just do that again, but this time successfully?
So speaking of the questions, Professor Pert and I were looking at those questions that you all submitted, and they're excellent. So I just wanted to say they're really, we're not going to get through them all, but they're really excellent questions. And this one as well. Okay, so the question here is, couldn't President Trump, in light of the immunity ruling, couldn't President Trump try to do, if he is reelected, try to do the same thing, but basically succeed in trying to subvert the election by leaning on the Department of Justice to fabricate voter fraud claims? So this is what I would say in response. It's similar to what I just said. Okay, can he do it lawfully? Like, would the law allow him to do that? First question. Second question, could he do it even though the law doesn't allow him to do it? Two different questions. All right, first question, could he do it under law? No, it would be illegal. He can't do that. There's all these statutes out there that say you can't do things like try to interfere with official proceedings, try to interfere with election proceedings, engage in corruption, lie to federal officials. So no, it would not be lawful for the president to do that, and that is true even if the president is never prosecuted for it, even if the president has immunity. But here's the thing, your lawyer can go ahead and tell you that, and you're like, right, but you need to do it anyway. So that's the second question, could he do it anyway? The question is, could a president lean on the head of the Department of Justice to begin investigations and prosecutions for concocted voter fraud claims? Absolutely. Absolutely. The president, as a matter of sort of just practically speaking, could a president who want to do that, yes. And the way you do it is you appoint somebody you nominate somebody that you think will do it for you, and if that person doesn't do it, you fire them, and then you go through the process of getting appointed someone who's in that position in an acting capacity and you think who's going to do it. And you keep doing that until the person executes the orders you're telling them to execute. But, and I'll try to make this answer short, the question is then what happens? Just because the DOJ starts to investigate voter fraud doesn't mean that the election then goes in somebody's favor. Instead, there's all these steps, and those you have to have for prosecutions. You're going to have a court sign off on it. You're going to have a jury sign off on it. You're going to have a grand jury sign off on it. If you're talking about subverting elections, remember those thousands of people I talked about? You're going to get them all having to sign off on it. Governors are going to have to sign off on it. Election boards are going to have to sign off on it. Courts are going to have to sign off on it. So will all those people sign off on it in the way that's required? I don't know. But what I'll say to all of you is that whether all these people who are checks on power, whether they hold the line or not, depends in large part on people like you as well as all of the rest of us out there. Because if it seems like it's going to be okay for government officials to break the law, they are more likely to break them. By contrast, if it seems like the streets are going to fill with people who are upset, right? If things are going to stop working, if people are going to start getting shunned, who are sort of participating in this sort of stuff, then it's much less attractive to bend the law in this way, and the rule of law generally holds. So that's where it starts really mattering if people start standing up against this sort of conduct. It's not a great answer, it's not a legal answer, frankly, but that is, from my understanding, is like basically the closest answer I can give you.
Thank you. I'm going to give 2 questions. These are for you, Danieli, and I think they're somewhat related. The first is, how can voter turnout be increased in economically marginalized communities? And second, and relatedly, should we prioritize political decisions on a local level to help people realize that civic engagement is effective and they can actually change something?
Those are great questions. Thank you. The first one, how to increase voter turnout. Well, there are lots and lots and lots of ways that people have thought about doing that, and I was focusing on this socialization piece. I don't want to pretend that's even the most important piece, so I want to just sort of go at the head of this. Like, there are lots of things we could do. We could make it easier to register. We could have universal registration. We could have voting systems like we have in Washington, where you just put your ballot in the drop box, which is very unusual nationwide. We could do lots of things. We could have holidays on voting. We could have early voting. There are lots of things we could do to eliminate barriers to voting. But in terms of the socialization piece that I'm talking about, I think that a really good example comes from the slide I showed you with the Head Start program compared to the TAM program. And the authors of that study and sort of where they're going with that is like, if we make programs, public programs, or if interactions with government are designed in a way to cultivate experiences of democracy, we build those sort of like muscles. We teach people that they are important, their voices matter, their views matter, and that does have a positive effect on voting and on civic participation. There's other studies that I didn't mention that compare Social Security recipients to TANF recipients and find that Social Security recipients receive very positive messages about their status as citizens, and their interactions with the Social Security system actually increase the likelihood of voting compared to TANF. So I think we could think a whole lot about how do we have people involved in the governance of policing, for example. There's a whole lot around like civilian oversight and around democratic policing, having people more involved in making decisions with police departments, and then also like having encounters with the government. I have to rethink policing fundamentally, and this is some of the work I've been doing in some of my research and writing, but having interactions with government that are not inherently subordinating. There's a lot more to say about education systems. Education is hugely important here, welfare, labor as well. And then the second question, what was the second question? I started to note down.
Should we prioritize local issues in order to empower people civically?
I think it really matters. I think that's a great idea. There's some research suggesting that local referenda, and things like that, are positive sort of experiences or sites of democratic socialization because people can directly participate and influence policy in a much more direct way than they can if they just vote for a representative. But I think it really matters who you're incorporating and how you're incorporating people. There's a big literature on participatory governance, and especially in like administrative law, and there's a presumed value to giving people the opportunity to participate in government decisions, like notice and comment. And there are scholars who have argued, like police should be required to kind of go through much more public participatory processes before they adopt policing policies. And this is similar, right? Like local governance, policing is at a very local level. Could we have local commissions where citizens weigh in? A lot of that's been proposed. One of the problems with that tends to be that the more opportunities for participation you create, if you don't do something to ensure that the most marginalized people are playing a central role in those systems, you actually wind up creating more opportunities for the powerful people to weigh in. Right, so when you have local governance over like environmental regulations or over policing, if you don't do something to monitor the composition of that governance, you wind up with just the local powerful actors really dominating. And so you have, yes, but you also want to think about the systems and the methods by which people are being incorporated into these local government structures, because they can just otherwise become vehicles that like replicate political inequality that exists at the federal level as well.
Thank you. Okay, Jeremiah, this one's for you. Can the president deploy armed forces domestically toward United States citizens?
Yes. Yeah, so could the president use their wartime or commander-in-chief powers against people and citizens in the United States? I mean, the closest stuff we've seen is like the deployment of the National Guard to ensure compliance with segregation, or what this makes me think about is the Youngstown problem, like the classic case that every constitutional law student is frustrated with is called Youngstown Sheet 2 versus Sawyer, where during the Korean War, because the Korean War depended so much on steel, there was a labor strike, and there was no cooperation between management and labor over the manufacturing of steel that goes into airplanes. I mean, you know, that stuff doesn't happen anymore. But so the union couldn't resolve the complaint, and the president, Truman, was really scared about what would happen if we ran out of steel, and so he, without authorization from Congress, nationalized the steel industry and said, hey, I run the steel mills for now until you can reach a labor and management agreement, because we really, really need steel because of national security and the national interest. The Supreme Court, in a rare kind of like disjoint, I mean, it was a majority, but a disjointed set of opinions said, well, you can't actually do that because nationalize the steel industry isn't in the Constitution. There are certain enumerated power, they're not enumerated, but there are certain inherent powers of the president, like, you know, receiving ambassadors or being the commander-in-chief, but there are also some implied powers, the way that Justice Jackson, the first Jackson, not the cool Jackson that we have now, but the first Justice Jackson said that there's, you know, the apex is when Congress and the president agree, right? Congress authorizes president to do X, president does X, everybody's happy, everyone goes home, we know the presidential power is at its height. Presidential power is at its lowest ebb when Congress doesn't, says the president shouldn't do this, but the president does it anyway, but there still could be grounds for the president to do it if it's in the, you know, squarely within the president's wheelhouse of their other executive powers. And then he says there's a zone of twilight between the two where Congress is silent. It kind of falls in either the Congress or the president's bucket of powers, and nobody's quite sure what to do. That sounds like a case that would be in the zone of twilight, but Justice Jackson said, actually, no, the president's powers are the lowest ebb because Congress didn't expressly authorize this. They authorized these types of national emergencies before, and because they failed to do it in this instance, the president wasn't authorized. So, very long way of saying, if their president decided to deploy troops domestically against United States citizens, it would have to be in an invocation of some kind of like imminent looming national emergency that also was authorized by Congress. If the president does it unilaterally, solely using command-in-chief powers domestically, then we are in for something terrible. You know, and so much like, you know, the other answer we've heard, constitutionally, could the president do it? Probably not. If the president did it, what would we do about it? Worry a lot and like hope for better outcomes and have to struggle for something greater. I don't know. That's not a very edifying or satisfying answer.
Yeah, and I agree that this is a difficult issue, and I agree with everything that Professor James said. What I would say in addition to that, and this is again completely consistent with this, is that Congress has passed statutes to address this issue, and the statutes essentially, as relevant, say in certain situations, yes, the president can have troops sort of act domestically, even with respect to United States citizens, but in certain circumstances, when there are certain conditions that have been met. So here's the thing, and it's the same theme that we keep coming back to. So the question is, well, what if the president says that it's because there's an insurrection in the state? But actually, we all know it's because the president is trying to suppress a peaceful protest of the president's own policies, right? So, under that scenario, it's sort of difficult to answer it from a legal perspective because somebody's basically asking you to pretend like something doesn't actually exist. Someone's basically saying, if the president does this and he says it's because it's an insurrection, isn't that lawful? And your response is, well, no, the whole premise is that he's lying. And so this is a long way of saying that if the president decides to point to some statute and lie about what the president is doing, that doesn't suddenly make it lawful. So I would say that unless you're talking about an actual insurrection happening in a state and a president in good faith deploying troops, my answer is it's unlawful. And then that gets us to the question, what happens if the president does it anyway? Which gets us back to, you gotta stand up against it. or accept it. Those are your two options.
If I could just kind of reinforce that, I think the tenor of the court's decisions, both in Trump versus United States and also in the case dealing with whether Colorado could remove Donald Trump from the ballot as an insurrectionist, the kind of bottom line answer of the court is, we're not solving this for you. This is about politics. Impeachment is a political decision. This is, if you don't like this person, don't vote them into office again. So the court's answer is basically the same, which is to say, like, we're not going to legally make this simple. Therefore, this is a question of politics. And again, it's interesting because that can sound like that's a very democratic thing to do, and like it's actually being humble and modest. But in fact, in some ways, it's a way of assuming power. The power not to decide can really be a power. Okay, I have a slightly optimistic question. Let me see if I can find it again. There's a lot of pessimism. So, okay, this is neutral. This might be pessimistic. There's a lot of misinformation and disinformation. These are rampant. What is a good resource for people to educate themselves in your areas or in this area that you think would be reliable? If people want to go and be better informed going forward, what do you recommend that they do?
Okay, so for what it's worth, one thing when you are a professor, you start having reporters call you and they ask you things. And so for what it's worth, I've seen from my side how some reporters operate. And what I've seen, one of the things that I had an hour-long conversation, it probably wasn't an hour, but I had a long conversation once with a reporter who was writing up some feature. And guess what? I did not appear in the article at all. And the reason why was because this was part of the fact-checking process. The person calls people up who have nothing to do with what's like not being quoted, haven't coordinated with the people who are being quoted, and they basically go through and they say, do you agree with this? Do you have any concerns, et cetera, et cetera, et cetera. It's part of a sort of a built-in systemic fact-checking process that the newspaper in question employs. So when you are, disinformation is hugely problematic, and it feeds into a lot of these different issues that we're talking about. So when you all are trying to figure out where to get your news, I would strongly recommend that you think about, in a sense, finding a brand. Think of it as a brand. What's your brand, New York Times? Is New York Times perfect? No. Do they have a robust fact-checking process? Absolutely they do. Same with Wall Street Journal, right? Same with Washington Post. Find a source that has, as part of what they deliver as a product, a fact-checking process. And you stick with those. They have podcasts. They try to make it bite-sizable. If you like that, try to find those sorts of resources, because those are generally going to give you more even-handed sort of information than sort of whatever's out there just being kind of thrown into the ether.
So my answer mostly is by citing to the great American philosopher LeVar Burton and his show Reading Rainbow to take a look, because it's in a book, and secondarily, you don't have to take my word for it. So the idea being that there are many sources of information, and the best way to avoid mis and disinformation is to check multiple sources, to cross-reference them, which sounds like work but doesn't take a significant amount of time in our modern age, and then also look at books that are peer-reviewed, that are checked by other folks. It isn't just about news sources, but also about understanding the context of how things are going on. Professor Evans did a fantastic job of citing to all these sources that are available for you to look at, particularly those who are students at UW. You have some of the best libraries, I think, available at your disposal, and importantly, some of the best librarians who can help direct you to the types of sources you might want to look for, both in terms of print media, digital media, things like that. So I think libraries, multiple sources, books are all very useful places for combating the level of news misinformation that we see.
I'm reminded of, I don't know if it was an experiment or an actual policy that was put in place. Maybe it's still in place because I sort of moved away from social media. But I know one of them, I don't know if it's Twitter or Facebook, but maybe just an A/B testing, not formal kind of thing, was doing something where every time somebody saw a news article, it would show them kind of like opposite source news article or multiple other sources of news articles. So if you are someone, to kind of counteract the filter bubble, where if you lean conservative, you only see conservative stuff in your feed, or if you lean liberal, you only see liberal stuff in your feed. If you're shown something conservative in your feed, they show you underneath, check out this very liberal-leaning article. And so I think I know I saw an empirical study showing that actually increased like openness and understanding, and I'm just reminded of that in this conversation. And so I'm wondering about even like thinking of that mentally in terms of your reading. It's like, what am I reading and where can I read the counter position? And always present, like looking at the different positions and kind of coming to your own views.
The one thing I'd add about this conversation when we're having a discussion often that centers around Supreme Court decisions is in a way that was not true for me when I was in law school. You have access to the primary sources. You can, not only can you read the opinions, and you might think, and they are too long. You might think they're too long, you would be correct. They are too long. But you can listen to the oral arguments. They're posted on an app called Oye, but you could Google around and find this. And especially if you're an undergrad and maybe you're not a poli-sci major, you might think, oh, it's gonna be too in the weeds, it's too complicated, I won't understand it. I encourage you to listen, because I don't think that's true. I think good common sense can get you through. Don't feel like you're not entitled to hear what's going on in the United States Supreme Court, which is the law that affects all of us. Feel like you can belong there. Feel like you can hear, you can listen, and you can have an opinion. Go directly to primary information and get that information for yourself. You don't always have to take your information filtered from other places. Just also to note that we do here have at the University of Washington the Center for the Important Public, which the goal of which and the mission of which is to discuss and prevent and sort of vaccinate us all against misinformation and disinformation. I just wanted to thank you all for coming and spending time listening to something that is both substantively challenging and sometimes can tip us into a little bit of existential despair in this season, and to ask you to resist that cynicism. Cynicism does not help you. It won't make you a happier person. It won't make the body politic more healthy. Think about ways that you can be an informed person and have these conversations, have conversations with people who disagree with you, and try to resist the temptation to feel like you may as well throw up your hands because it's just all gonna go down. We hope that our presentation today can at the same time be critical and also not show you that we are not giving in to that cynical despair. We think there's a lot of work to be done and that many people can contribute to that work. So I wanted to say thank you for coming and listening. And also, for those of you who have enjoyed this, the last of the series in this democracy series, Who Votes and Why Voting Matters, will take place on October 29th, so next week. And hopefully you might take the time to come to another one of these lectures. Thank you very much.
As the Dean of the School of Law, I would just like to again thank our law faculty and also invite you, if you're maybe a prospective law student in the future, we have Social Justice Tuesdays every week at the law school. We have a lot of engaged events, and please join us when you're free. Thank you for this engaged conversation.